Hello and welcome back to another video on my channel. Today we're going to be asking whether or not law school could be right for you. Now this is something that's been talked about a lot on YouTube, but typically they say, would you enjoy arguing for a career? Or are you interested in the amount of money that you would make as a lawyer? And things like that. And I'm going to try to avoid that and take a more grounded approach into what I believe law school actually entails, and that is thinking like a lawyer and case law. And so if you can enjoy these things or appreciate them, then I think you're going to enjoy law school and the career of a lawyer. So let's go ahead and get into it. Now, in this video, I'm going to walk you through three first-year law school cases. One of them is going to be from criminal law, one of them is going to be from torts, and another one from constitutional law. First up, we have tort law. This is where we're going to study civil wrongs, cases where one person harms another and the victim seeks compensation. Our case today is going to be Eichenwald versus Rivello from 2018, and the issue in this case, can sending someone a flashing GIF on Twitter constitute battery when it causes them to have a seizure? Now, the rule is that battery requires an intentional act that causes harmful or offensive contact with another person. Now, the key question here is whether light from a digital image is going to qualify as impact. Here, Kurt Eichenwald is a journalist who publicly disclosed that he has epilepsy, and in December of 2016, Rivello sends Eichenwald a tweet containing a rapidly flashing strobe GIF with the message, "You deserve a seizure for your posts." When Eichenwald viewed it, he then suffered a very severe seizure and his wife had to take care of him. But Rivello argued this couldn't be battery because there was no physical contact on his part. It was just pixels on a screen, but the court disagreed. The court explained that when Eichenwald viewed the GIF, photons from flashing light hit his retina, they were converted into electrical signals and triggered a seizure. That's a physical process, and the light waves made contact with his body and caused harm. The court emphasized that Rivello knew Eichenwald had epilepsy and specifically intended to cause a seizure, as evidenced by the GIF and what it said. The strobe GIF was a physical tool designed to harm, just like mailing someone a bomb or anthrax. Now again, this is on the motion for summary judgment level, and so the standard is a lot lower, and this is not a case in where you figure out how much money was won or anything like that, but it is merely the court finding this is a plausible case for a tort. So ultimately, the court allowed Eichenwald's battery claim to proceed beyond the motion for summary judgment, and this case was groundbreaking at the time because it showed how traditional legal doctrines can apply to these new technologies. Even though the medium was digital, the harm was still physical, and the law adapted in this case. Okay, next up, criminal law, the big thing is you need an actus reus and a mens rea. So you need a physical act and you need the intent to go with the act. Now, the issue in this case of United States versus Jewell is, can a defendant satisfy the knowledge requirement for a crime through willful blindness? That is, deliberately avoiding learning the truth of what's going on. Now, ultimately, the court holds that under federal law, knowledge can be established not only through actual awareness, but also through willful blindness. And willful blindness, occurs when a person is aware of a high probability that a fact exists and deliberately avoids confirming it, This idea of, I'd rather not know, or the less I know, the better, and that's going to allow me to get away with this crime, that's not going to hold up in court, and this case is an excellent example of that. In Jewell, the defendant was approached at a bar in Mexico and offered $100 to drive a car across the U.S. border. He accepts. The car had a secret compartment which Jewell noticed but chose not to inspect, and when customs searched the vehicle, they found 110 pounds of marijuana hidden in that compartment. Jewell argued he didn't know there were drugs in the car because he never actually looked. But the court said that that's exactly the problem. He suspected something was up. He knew about the compartment, he was offered money for a simple drive by a suspicious person, and he deliberately chose not to investigate the matter further. The court held that this kind of willful ignorance does satisfy the knowledge requirement. In conclusion, the Ninth Circuit affirmed Jewell's conviction, and the takeaway was that you can't stick your head in the sand and claim that you didn't know. You can't claim innocence in that situation. If you have reason to believe something illegal is happening and you deliberately avoid confirming it, the law treats that as knowledge. Finally, the last and final case of the day, this is going to be constitutional law. It's a big one. You'll study the structure of government in constitutional law, separation of powers, federalism, individual rights, and this case is going to be challenging, but it's incredibly important, So the one we're covering today is going to be United States versus Carragher from 1953. I just really liked this case when I was in con law, and it's about gambling and the ability of Congress to regulate it, and I think it's more relevant now than ever with the increase of sports betting and things like that, where Congress has the power to regulate it, but it's ultimately chosen not to. So the issue in this case was, first, can Congress use its tax power to regulate gambling, an activity traditionally controlled by the states under the 10th Amendment? Second, does requiring gamblers to register violate the Fifth Amendment's protection against self-incrimination? Now, the rule ultimately is that Congress has broad power to tax under Article 1 of the Constitution. A tax doesn't become unconstitutional just because it has a regulatory effect or raises minimal revenue. Additionally, the Fifth Amendment protects against being compelled to testify about past criminal acts, but it doesn't prevent the government from requiring the prospective compliance with tax law. So the application to this case was that the Revenue Act of 1951 imposed a $50 annual occupational tax on people in the business of accepting wagers. It also required them to register with the IRS. Now, Joseph Carragher was charged with failing to pay the tax and register. He challenged the law on two grounds. First, he's going to argue that Congress was using its tax power as a pretext to regulate gambling, which is a state police power reserved by the 10th Amendment, left to the states. The Supreme Court rejected this argument, and the court said that even if the tax discourages gambling or raises a little revenue, it's still a valid exercise of the tax power. Congress has used taxes to regulate activities before, and here think about taxes on firearms or narcotics, and the court wasn't going to second-guess Congress's motives here. Now, Carragher's second argument is that the registration requirement violated his Fifth Amendment right not to self-incriminate. Now, the court disagreed again, and here they said that the Fifth Amendment protects you from being forced to confess past crimes, but it doesn't protect you from having to comply with future tax obligations. The registration was forward-looking, not backward-looking, and here there has been developments since this case was decided in '53 on the second issue, but the conclusion was ultimately that the Supreme Court upheld the tax. Carragher's conviction stood, and this case is important because it shows the breadth of Congress's power, even when that power is being used to regulate behavior that Congress couldn't directly control otherwise. So this was your snapshot of law school and what it's really like, with real cases and a close reading of them and careful reasoning. This is what you're going to spend your time doing for like 3 years, and you're going to be reading opinions like these, briefing them, and arguing about them in class with your peers, and ultimately you're going to be learning how the courts think and how they reason through the law. All 3 of these cases are linked below, and I strongly encourage you to read them for yourself. Thanks for watching, and again, I hope you have a great rest of your day as always.